Hello and welcome to a 10-minute talk through on what it is on the Constitution. So, as discussed, I'm not going to do this with any kind of visuals or aids, but it's 10 minutes to go through one of the most tricky areas to summarise in the entire course, because I like a challenge. So, here we go, without further ado. If I have to look down, I do apologise, I'm checking my notes. The Constitution in the UK comes from 6 sources. There's the Acts of Union, there's Magna Carta, there's the Bill of Rights in 1689, there's the European Communities Act in 1972, though that could be being repealed. We could argue that that's now over due to 2019, and the Parliament Acts of 1911 and 1949. The concept of our Constitution being uncodified and unwritten down is this idea of limited government, and was first put forward by John Locke in 1689. In 1689, the Bill of Rights was based on John Locke's idea of a limited government and therefore being unentrenched and uncodified so that it was nimble and could be adapted to fit the freedoms of any given area. It links to liberalism and the idea of limited government. This means in the UK, we've ended up with a parliamentary sovereignty. That is, Parliament is sovereign. Over time, Parliament has taken more and more of the powers away from the monarch and have collected them for themselves. And this means that Parliament acts with only one brake on its supreme power, the rule of law. And that is that everybody is equal before the law. We are also what's called a unitary state. Every aspect, every nation of the United Kingdom comes under the same state, and therefore that state has the ultimate authority in all matters. Contrast that with the US, which is a federal state, and where individual states have the ability to do various things without the say-so of central government. There are a number of sources of the Constitution and where to get them from. The first of these is statute law. Statute law is any law that's been passed by Parliament, becomes an act, and is then written down in law books and is legally enforceable by the judiciary. Now, strictly speaking, any parliament is not subject to the laws and ideas of a previous parliament, but then they'd have to take the active step of repudiating or repealing existing statute law. Until such time, they provide a basis for the Constitution. An example to prove a point would be the Scotland Act of 1998, which set up Scotland as a devolved power. There's also the Equality Act of 2010, which essentially said that all anti-discriminatory legislation came under a single heading and that no one was allowed to discriminate on any basis. In other words, the positive right of equal treatment. The next one is common law. So sometimes the courts have to adjudicate on areas where statute law is either unclear or simply doesn't cover an area. And these are therefore based on precedent or on judgments made about that particular area. Let's take, for example, Entick versus Carrington, which is the one about government not being able to trespass. So they can't send bailiffs in without a court warrant or a court order. And this says that the government has no right to, well, take your property without your consent. Consent can be provided in a number of different ways, and it can be provided legally as well as actually. There's also, what was the one? Somerset versus Stewart, which meant slavery in the UK vanished in a puff of logic. So you've got statute law and common law. Statute law passed by Parliament, common law where a judgment is made by a judge in a court that allows for a certain idea to become entrenched in the idea of how the laws are enacted. It's unclear in the statute law. Next is conventions. Now these are almost made up things. They're kind of agreements between different people about how things should operate. But there's no sort of written version of these, and there's no guarantee of any of them. They're traditions. They build up over time. And conventions have developed a bit like common law to deal with things as and when they arise. These can change over time. So a good example of this was Alec Douglas Home, who resigned. Do you resign a peerage? You resign his peerage, fought a by-election so that he could sit in the House of Commons before he became Prime Minister and leader of the Conservative Party. There's the Salisbury Convention. The House of Lords will seek not to block any legislation that's been promised by an existing majority party that they've been elected on in their manifesto. Basically, if it's in the manifesto, the Lords won't block it. And this was done for various reasons that you don't need to know, but the point is that's why it's there. The House of Commons convention that they get to vote on and discuss military deployment was set in 2003. And if you'll recall, that's already been mentioned with Robin Cook's speech, if you've been following Year 12 videos and the video on Parliament. Another convention is about referendums, and recently that's become a big deal. If a decision is big enough, that they tend to go to the public. Parliament will ask the public what they think. So we've got statute law, we've got common law, and we've got conventions. Next on the list, number 4, is landmark decisions. Landmark decisions are basically any of the aforementioned areas that are so big they become impossible to ignore. So Magna Carta recognised that there were limitations on the power of the Crown, and as the Crown is essentially embodied by the Queen in Parliament, thus by Parliament, there are limitations on parliamentary power, and that concept and idea remains intrinsic in our constitutional understanding. There's the Petition of Right in 1628, which essentially said that you're allowed to be free from the threat of arbitrary imprisonment. There has to be a reason for you to be imprisoned. And Parliament grants taxation. It's why the House of Commons has the ultimate right to agree or disagree on a budget. The Bill of Rights basically says Parliament got supremacy over the Crown. That was in 1689. And if you remember, it was set up immediately after the Glorious Revolution of 1688, where Parliament invited a king in. It also, by the way, bans illegal and cruel punishments, which is a bit like the Geneva Convention, but with slightly different wording. So they're pretty landmark decisions. They're big dates, big things. They're also authoritative works. That's number 5. And authoritative works are books by scholars and people involved in the political process that seek to map out how things work in Parliament. And they get so well known and they get so authoritative that people refer to them. So Erskine May was a clerk of the House of Commons and lived between 1850 and 1886, published Parliamentary Practice in 1844, and it was referred to in March 2019 in the House of Commons when John Bercow said that there couldn't be a third reading of a government bill if it was substantially unchanged, which upset May. Erskine May was thus used as a precedent in Parliament, and thus it became undeniably an authoritative work. There's also A.V. Dicey's Introduction to the Law of the Constitution from 1885, talks about parliamentary sovereignty and the rule of law. And there's also Bagot, who has turned up a lot, baggy hot, the English Constitution, 1867. The 6th and final area that we're talking about are treaties, international treaties entered into by Parliament. Although Parliament is sovereign, it would have to specifically go back and repudiate those treaties in order to get rid of their influence. Now, to be fair, there was the Treaty of Rome in 1957, and when the UK joined the EU, it had to accept the stipulations of the Treaty of Rome, such as the Single European Act, the Maastricht Treaty, and the Lisbon Treaty, that all harkened back to the Treaty of Rome. Since Brexit, and that's now a thing, those treaties no longer have any force. But the EU Withdrawal Bill, that's now an EU Withdrawal Act, that's now the law, does have legal backing. So the business about a border in Northern Ireland, between Ireland and Éire, is a thing, and one of the protocols, Protocol 16, I believe, dealing with that is legally binding, and thus affects constitutionally how things can be run. The next thing to talk about is the relationship between them. Basically speaking, the way it works is the courts tend to adjudicate on these matters, not because they're given any particular power like in the US system, but because that's the way it's been. So the Factortame case is the got one here, where in 1991, European law took precedence over UK law. How's it developed? Devolution is one of the biggest developments, and we talked about devolution in local government, and you talk about Wales and Scotland. There's the House of Lords reform from 1999, when Tony Blair changed the number of life peers and got rid of hereditary peers. There's electoral reform, though nothing's actually come of that. There's the Human Rights Act in 1998 that's changed the way the Constitution works, setting out for the very first time positive rights in the UK system. Remember, we have a negative legal system, so a positive set of rights is a big deal. We set up a Supreme Court in 2005 under the Constitutional Reform Act of 2005, thus taking the law lords out of the House of Lords and making a separate body whose job it was to adjudicate on legal matters. There was the Fixed Term Parliaments Act under the Coalition in 2011, though you could argue for days about the effectiveness. There's parliamentary reform in terms of the enactment of the Right Committee, where they've got backbench committees so that they can organise their private members' bills. There was further devolution, but we talked about devolution. There's elected police commissioners, and in the Recall of MPs Act of 2015, that was a constitutional change. We've got EVIL, English Votes for English Laws, and we've got the IndieRef of 2014, which are both potential changes to UK Constitution, though as yet they haven't made huge changes. You can go into more depth if you wish. The last bit is how it could be further reformed, and they are the main arguments about having an elective House of Lords, about electoral reform at Westminster, do we change from first past the post, about whether or not there should be English devolution, which apparently is a huge debate, but people aren't really interested in it, which is actually the debate, and whether or not we need a codified constitution, because of things like the Terrorism Bill and the Investigatory Powers Act 2016. I've now gone 1 minute over my 10-minute budget, but I had that intro where I started, so I don't feel too badly about that. Hopefully, this 10-minute summary of the Constitution is useful. If you want to play it again on 1.5 times the speed on YouTube, be my guest. I'm now hitting 11 minutes and some, so it'll be 12 minutes by the time this is finished. And I hope it's been useful to you. Thank you, if you have been, for watching. Do check your notes, and I'll see you in the next one of these if you like this. Bye-bye now.